people know, for those of you who are not familiar with the Children's Commission, what the Children's Commission does. We oversee federal court improvement funds that are allocated to each state to improve the legal system that handles child welfare cases. So we do things like put on conferences for judges. We develop materials like our toolkit for attorneys representing parents and children and our bench book for judges. We commission studies, we provide grants, and we also serve as a resource to the legislature regarding child welfare legislation, and we track all legislation that's related to child welfare. And what I want to let people know is that the bills listed in this report are not exhaustive of all the bills passed in the 88th regular legislative session, but they do represent the Children's Commission's best efforts to identify the legislation that is most relevant to child welfare and child welfare practitioners. In this report, some bills directly related to child welfare will have all citations listed. Some bills which are less directly related to child welfare will be listed with a notation that they contain some additional citations that we won't cover in this presentation. It's also important to note that the material in this update should not be construed as an advisory or ruling by the Supreme Court of Texas or any other court on any specific case or legal issue. This report is solely intended to address the improvement of the law, the legal system, and the administrative justice. I also wanted to just highlight a few housekeeping matters. The PowerPoint for this presentation will be made available for free on the Children's Commission website, along with a legislative update that will break down the bills in further detail and separate all of the updates by code section in the particular law that they're related to. Also, the MCLE information will be provided at the end of this presentation. So I wanted to move and provide a little bit of context on child welfare legislation and trends we've seen in it over the past 3 years. And as you can see, the activity regarding child welfare legislation has consistently increased over the last 3 sessions. It may not get as much attention from the media regarding the Texas legislature, but it's increasingly an active area of legislation. We did see a lot more bills filed this session than last session, although fewer passed. But the activity and the interest in child welfare as a subject matter is something that seems to be increasing each legislative session. I want to start with House bills, and I'm going to focus most of my time on the most significant bills, but there are a lot of bills that we'll get covered. We have reserved some time at the end for questions, so if you have questions, please submit those to the Q&A function, and we should have time for most questions at the end of this presentation. So as I said, I'm going to focus most of my time on the most significant bills, and one of the most significant bills was House Bill 63 by Representative Swanson. It is effective September 1st of this year, and it has to do with anonymous reporting to the CPS hotline. And what it effectively does is it removes the option to report anonymously. It amends Family Code Chapter 261-104 to require an individual who is making a report of child abuse and neglect to the DFPS hotline to identify themselves and to submit contact information. The reporter has to be informed that DFPS may not accept anonymous reports and that the reporter's identity will remain confidential, but the reporter can make an anonymous report to law enforcement. If the report is being made over the phone, the caller also has to be notified that the call is being recorded and that making a false report is a crime. It also clarifies and tightens who at DFPS can have access to the confidential reporter's identification. So only a DFPS employee that is directly involved in the case, or an employee that is the supervisor of a directly involved employee, or an employee that has a legitimate interest in the investigation can have access to the confidential reporter's information. If a person does make an anonymous report to law enforcement and that agency then makes a report to DFPS, DFPS must conduct a preliminary investigation to corroborate the report. So anonymous reports can still be made, but the channel is they have to be made to law enforcement, which then refers to DFPS, which then conducts a preliminary investigation. It also makes changes to Family Code Section 261-307 that is related to the conduct of DFPS investigators. And it requires DFPS to provide information to a parent or the other person with legal custody being investigated regarding the DFPS employee's identity and the DFPS investigative summary. The DFPS must allow a reasonable amount of time for the parent or the person to read or review that summary before taking any further action in investigating the report of abuse or neglect. So moving on to House Bill 422 by Representative Van Dever. This has an effective date of June 13th, so it is already in effect. And what this bill does is it is related to whether or not a detention hearing can be conducted remotely. So it amends Family Code Chapter 54 to authorize a juvenile court to conduct a detention hearing remotely without the consent of the parties, unless consent is specifically required by the U.S. or Texas Constitution. It further amends Chapter 54 to require that a court may allow or require remote participation by a party, a witness, a court reporter, or other individual at a detention hearing. The juvenile court must submit a plan for remote proceedings to the Office of Court Administration that includes the protocols for handling physical evidence and requires an unobstructed view of those who are providing remote testimony. It also repeals Family Code 54012, which had previously prohibited detention hearings from being done remotely. Moving on to House Bill 474 by Representative Hull, that is effective September 1st. This bill relates to CASA volunteer advocates and CASA programs. It amends Family Code 264 to define active and inactive volunteer advocates. It also requires reporting of the number of active and inactive volunteer advocates in CASA's contract goals. It requires CASA programs to adopt a grievance procedure and maintain records regarding active and inactive volunteer advocates. Moving on to House Bill 730 by Representative Frank, that is also effective September 1st of this year. This is easily the largest and most significant child welfare bill this session. It covers a lot of different areas, and so we'll be spending a lot of time on this particular bill. And one of the first things the bill does is try to create some finality regarding investigations that have been closed. So it adds new language to Family Code Chapter 261, so that if 60 days have passed after an investigation was closed, DFPS may not reopen that investigation. DFPS may reopen an investigation that's closed within 60 days if good cause is shown in procedures established by DFPS to reopen that case. It also makes significant changes to Family Code Chapter 261-303, and this is the provision regarding orders in aid of an investigation. And what it does is essentially creates two sort of burdens of proof depending on the severity of the allegation. So a court may order admission by DFPS to the home, school, or other place where the child may be for an interview, examination, and investigation if the court has good cause to believe the child is in imminent danger of aggravated circumstances, or if the court has probable cause to believe the admission is necessary to protect the child from abuse or neglect. So that different standard depending on the severity of the allegations being investigated. To order the release of records by the parent, or to order a medical, psychological, or psychiatric examination of the child, the court has to have probable cause to believe the order is necessary to protect the child from abuse or neglect. Continuing on with 261-303, it also amends the statute to clarify that a hearing for an order under this section may not be ex parte unless the court has probable cause to believe there is no time consistent with the health and safety of the child for a full hearing. And the statute was previously silent about whether or not an ex parte hearing was either authorized or required. And so this clarifies when an ex parte may be permitted under this statute. The order must also include the court's findings regarding the sufficiency of the evidence, and the court has to provide a copy of the order to a party on request. Importantly, this provision applies only to an order rendered on or after the effective date of this act. Moving on to Family Code 261-307. Again, as we saw earlier, this deals with the conduct of the DFPS investigator and establishes some Miranda-style duties upon that investigator. So it requires the investigator, upon first contact with someone being investigated for allegations of abuse and neglect, to be provided with a written summary that now must include an explanation that any statement or admission made by the person to anyone may be used against that person in a criminal case as a basis to remove the child or as a basis to terminate that person's relationship with the child. The summary also has to include the known allegations that DFPS is investigating, and they have to verbally notify the person of their right to not speak with an agent of DFPS without legal counsel present, to receive assistance from an attorney, to have a court-appointed attorney if they are indigent, they are the parent of the child, and DFPS seeks a court order under Chapter 262 or 264. The right to record any interaction or interview, subject to the understanding that that recording may be disclosed to DFPS or law enforcement or another party under the court order. that they have the right to refuse to allow the investigator to enter the home or interview the children without a court order. They have the right to legal counsel present before allowing the investigator to enter the home or interview the child. They have the right to withhold consent to release of any medical or mental health records, the right to withhold consent to any medical psychological examination of the child, the right to refuse to submit to a drug test, and the right to consult with legal counsel prior to agreeing to any proposed voluntary safety plan. Continuing on with 261-307, it's also important to note that DFPS has to document that verbal notice was provided to the person, and DFPS has to adopt a form to document that the person received both a written and oral summary and provide a signed copy of that document to the person's attorney if that person is represented. And importantly, it also establishes an exclusionary rule. So if the person does not receive both this verbal notification and written summary, any information obtained from that person and any other information that would not have been discovered without that information is not admissible for use against that person in any civil proceeding. Now, this applies only to an investigation of report of abuse or neglect made on or after the effective date, but I want to pause just a little bit and focus on that exclusionary rule because you have to have both the written and the verbal notification to prevent triggering this exclusionary rule. Also, this is a fairly substantial exclusionary rule and that excludes this information not merely from suits filed by DFPS, but from any civil proceedings. So that would include protective order proceedings under the Family Code. It would include custody actions, and it would include any tort action as well. So it's a fairly substantial exclusionary rule. Moving on to the changes it makes to Family Code 261-308. This requires DFPS to notify the child's parent, the child's attorney if they're represented, the ad litem for the child, CASA, or the guardian ad litem, or any other persons the court determines has an interest in the child's welfare of any changes or edits to the DFPS investigative report. It also makes changes to Chapter 262 of the Family Code. It requires ex parte hearings under Chapter 262 must now be recorded either by audio or video or a court reporter transcription. The court has to provide a copy of the recording to any party upon request, and DFPS has to provide notice of the hearing to that parent's attorney if they are represented. So the hearing can still be conducted ex parte, but if the parent is represented, they have to be notified that that hearing is going to take place. It also applies only to ex parte hearings held on or after the effective date of the act. Moving on to changes the bill makes to Chapter 264. So this is a change made to what is often referred to as the court-ordered services statute, sometimes as the motion to participate statute. And what this amendment does is it clarifies that while courts can make temporary orders regarding the safety of the child, they cannot issue a temporary restraining order under 105-001 that places the child outside the child's home or in the conservatorship of DFPS. So it's a restriction on ordering a child outside of the home in a petition filed under 264-203. And that's going to be important when we talk about some of the other changes made by this bill. Moving on to other changes under Chapter 264, these are regarding parent-child safety placements that DFPS engages with families where they agree to place the child outside the home for safety reasons. So there's several changes that relate directly to PCSPs in this bill. It requires DFPS to report the number of Family Code Chapter 264 cases where a parent-child safety placement is in place, where a court also orders a parent, managing conservator, guardian, or other member of the child's household to participate in services. I think it's important to keep in mind, though, that as we saw earlier, under new provisions of 264, the court cannot order a parent to place their child outside the home under a 264 case. So this cases that are being reported must include voluntarily parent-child safety placements because they cannot be court ordered. Moving on to the other changes regarding PCSPs, the changes Family Code 264-901 to define a PCSP as any temporary out-of-home placement made in written agreement with DFPS and the parent or caregiver that ensures the safety of the child during an investigation or while the parent or caregiver is receiving services. The previous version of the statute said it applied to a temporary out-of-home placement. This makes it so it applies to any temporary out-of-home placement. Moving on to changes made to 264-902. So it clarifies that before a parent may enter into a PCSP, DFPS has to notify the parent of their right to counsel and give them a reasonable amount of time to consult an attorney. PCSPs now automatically terminate after 30 days, but it does allow DFPS to enter into not more than 2 30-day extensions. Upon entering a PCSP, DFPS must inform the parent of their right to refuse to enter the agreement and to be represented by an attorney or a court-appointed attorney if they are indigent and DFPS seeks a subsequent court order. DFPS may not place a child in a PCSP for longer than 90 days unless both the parent and their attorney sign the agreement or a court renders an order under Chapter 262. Written notice of certain provisions also have to be placed within the PCSP, and this applies only to PCSPs executed on or after the effective date. And I want to highlight something because I think it's easy to miss, but I think it creates a significant option for a parent that is represented that is not available for a parent who's unrepresented, and that a parent who is represented can voluntarily agree to extend a PCSP longer than 90 days, but a parent who is not represented does not have that option. They cannot agree to an extension longer than 90 days. And as we saw earlier, the court does not have the option to order a PCSP in a court-ordered services case. So there are fewer options available to a parent who does not have representation in that circumstance. Moving on to Family Code 264-907. This requires DFPS to separately include the number of children who are placed in PCSPs in their reports submitted to the U.S. Department of Health and Human Services regarding the number of children removed from their homes. So not merely children who have been legally removed from their homes, but children who have also been voluntarily placed outside the home have to be included in the numbers sent to the federal government. Moving on from House Bill 730 to House Bill 793, by Representative Noble, that's also effective September 1st. This bill allows a parent to select their own service provider. So it amends Family Code 263 to allow a parent to obtain services in their service plan by a qualified or licensed provider that's been selected by the parent. The services must be designed to achieve the goals of the service plan, and they may be provided remotely. The provider must certify that the parent has satisfactorily completed the service, and DFPS has to reimburse the service provider at the same rate as DFPS's contracted providers in the region. But that means if the provider is outside the region, they're still reimbursed at the same rate as providers in the region. It applies only to a suit filed by DFPS on or after the effective date of this act. Moving on to House Bill 844 by Representative Patterson, also effective September 1st. This amends the Code of Criminal Procedure, Article 56B, regarding solicitation or patronization of forced labor or services, including sexual conduct, and it adds that to the definition of criminally injurious conduct if it occurs in connection with a scheme that constitutes human trafficking. And importantly, victims of that conduct are considered trafficking victims for the purposes of grant programs that are administered by the Office of the Governor. So if you have a client who you think is a victim of human trafficking, it's important to know what programs and grant programs might be available to them. This applies only to conduct occurring on or after the effective date of the act. Moving on to one of our other important bills or major bills, House Bill 968 by Representative Gates, also effective September 1st. This bill has to do with reasonable efforts by DFPS to avoid the needful removal in the first place. So what the bill does is it amends Chapter 262-101. This is the section regarding emergency removal affidavits when DFPS is seeking a court order to authorize removal. And what it adds is it adds to that affidavit a requirement that they have to explain why the child could not be protected by a kick-out order of the perpetrator of the abuse or neglect, or by placement with a relative or designated caregiver under a PCSP because it was refused, was not possible, or that placement would pose an immediate danger to the child. Also, the affidavit has to describe all reasonable efforts that were made to prevent or eliminate the need for the removal of the child. I also want to just highlight that it's important to note that as we saw with the amendments to PCSPs, House Bill 730 seems to be curtailing the use of PCSPs, but House Bill 968 seems to want an explanation as to why they were not used to prevent removal. Also, I think it's important to factor in the difference again for unrepresented parents, because as again, an unrepresented parent may not be able to agree to an extended PCSP. So that may be a reason why a PSP was not possible in certain circumstances. One of the other major things the bill does is authorize an agreed kick-out order. So rather than having a court enforce the order, a party may agree to an order removing them from the home under new Chapter 262-1016. So a perpetrator can agree to remove themselves from the home. That order may not be used against the alleged perpetrator as an admission of child abuse and neglect. And while it's enforceable civilly or criminally, it is not enforceable as a contract. The person who is affected by this agreed order may request that the court terminate the order, and the court has to terminate the order must terminate the agreed order upon a finding that the order is no longer needed and that terminating the order is in the best interests of the child. So the bill makes similar findings that we just saw regarding the affidavit when DFPS requests a court order to authorize removal, and makes those same findings of ruling out a kick-out order against a perpetrator and ruling out why a PCSP could not keep the child safe to the findings a court must make in that circumstance. It adds those same findings to the affidavit that has to be filed in an exigent circumstance where DFPS removes the child from the home prior to a court order, and includes the same requirements in the affidavit that they have to describe all reasonable efforts that were made to prevent or eliminate the need for removal. And it makes, again, those same changes in the order under Chapter 262-107 that is made by the court after an exigent removal prior to a court order. That same requirement to explore a kick-out order and explain why a PCSP would not keep the child safe is placed in that findings as well. So moving on to House Bill 969 by Representative Cook, also effective September 1st. This is a bill that's related mostly to child custody, but I think it's important for people to know because it amends Family Code 157 to authorize counties and municipalities to impose a fine up to $500 for interference with a child custody order. So when you're at the end of the case and you are going over those final orders with clients, if you're having a final order that modifies or shares custody, this is an important thing to be aware of. Moving on to one of our other major bills, this is House Bill 1087 by Representative Hull, also effective September 1st of 2023. This bill also has to do with reasonable efforts, and I think, interestingly, the most significant change it made was actually added to the bill at sort of the very last stage. This section regarding 161.001 was added as an amendment to the Senate bill after the bill had already passed the House. And there wasn't much discussion about this particular provision, but I think it's by far and away the most significant thing the bill does, because it effectively adds a third prong to the termination statute. So now under 161, this bill restricts a court from ordering termination of parental rights in a suit filed by DFPS unless the court finds by clear and convincing evidence that DFPS made reasonable efforts to return the child to the parent before the commencement of trial on the merits, and despite those reasonable efforts, a continuing danger remains in the home that prevents the return of that child to the parent. Now, interestingly, the court does not have to make this finding regarding reasonable efforts at termination if the service plan for the parent was waived due to aggravated circumstances. So if the court has found aggravated circumstances at the beginning of the case waiving the service plan, they do not have to make this reasonable efforts finding at the termination stage of the trial. The court also has to include in its final order a separate section of the written findings describing with specificity the reasonable efforts made by DFPS to return the child to the child's home. I just want to also highlight that while the bill doesn't cover the reasonable efforts findings that are made at permanency hearings, I think those findings will now take on a new significance given that reasonable efforts are now required to prevent or required to authenticate termination of parental rights. So I think those permanency hearing reasonable efforts findings will take on new significance in light of this change to the family code. The bill also makes some changes to 262.101, similar to 968 that we just saw. It requires an emergency removal affidavit when DFPS seeks a court order to remove, to describe with specificity in a separate section all the reasonable efforts made to prevent or eliminate the need for removal or to return the child home. It adds the same requirements in the order that the court has to make when DFPS seeks authorization for emergency removal. And then it adds the same for an affidavit that is made after DFPS does an exigent removal prior to a court order. And again, the same language to the findings a court makes after an exigent removal prior to a court order. So all of those orders have to, with specificity in a separate section, describe all the reasonable efforts that were made to prevent or eliminate the need for removal of the child or to return the child home. It also makes changes to the adversary hearing statute under 262.201, and it requires the adversary hearing orders to also describe with specificity in a separate section all the reasonable efforts made to prevent or eliminate the removal of the child or to return the child home or to place the child with a non-custodial parent. So that's an important difference from the previous language that we just saw. Also, this applies to a suit affecting the parent-child relationship that is filed on or after the effective date of this act. So moving on to House Bill 1423 by Representative Campos. This bill has to do with protective orders regarding people who are released from incarceration. So it amends Family Code Chapter 85 so that as soon as practicable after the release of a person from incarceration who is subject to a protective order, the Department of Public Safety has to update the statewide law enforcement information system to reflect the date the order will expire following the person's release. Importantly, this provision applies only to an order with respect to a person released from incarceration on or after the effective date of the act. It also changes Family Code Chapter 85026 so that each protective order must specify when the order expires and must provide notice of any extensions that may apply as a result of that person's confinement or imprisonment. That provision applies only to a protective order issued on or after the effective date of the act. Moving on to House Bill 1432 by Representative Meza. This bill has to do with the findings required for family violence. And for previously, family violence filings have had a two-pronged test. The court has had to find that family violence occurred and was likely to occur in the future. What this bill does is it removes that second prong of likely to occur in the future, making it a single-pronged test. So it amends that in the Code of Criminal Procedure regarding a protective order regarding stalking. It amends it in the Code of Criminal Procedure regarding a protective order for an offense motivated by bias or prejudice. It amends it in Family Code Chapter 81 regarding the general provisions of a family violence order. It also amends it in Chapter 81 regarding the presumption of family violence. Significantly, it also strikes that seeking or attempting to seek contact with the child from the list that trigger that presumption. So that's been a different section that's also been removed. It also removes it from the section striking that findings that have to be made at the close of a protective order hearing, as well as regarding violations of an expired protective order. And then finally, it strikes that requirement from the provision in the law that allows protective orders to exceed 2 years. So all of those provisions apply only to a protective order that is rendered on or after the effective date of the act. Moving on to House Bill 1506 by Representative Meyer, also effective September 1st. This extends the statute of limitations for certain crimes regarding children. So it increases the statute of limitations for the criminal offense of abandoning or endangering a child to 10 years after the victim's 18th birthday. So that's significant in that it extends that time not from when the incident occurred, but from when the child turns 18. It does not apply to an offense if the prosecution of that offense becomes barred by limitation before the effective date of the act. House Bill 1796 makes similar changes regarding the criminal offense of child pornography. It extends that to 7 years after the victim's 18th birthday. And for trafficking persons or sexual performance by a child, it extends the statute of limitations to 20 years after the victim's 18th birthday. And again, they do not apply if the offense was barred by limitation before the effective date of the act. Moving on to House Bill 2187 by Representative Davis. This was a bill that affected the criminal statute regarding abandoning a child, and it added abandoning an elderly or disabled person to that criminal offense. And it also added that regarding the termination that can be done based on that criminal statute. And it did the same thing for the provision for aggravated circumstances. So now under Family Code 161.001, appearance rights can be terminated for abandoning an elderly or disabled person in addition to the criminal offense of abandoning a child. And likewise, aggravated circumstances can be pursued if a parent abandoned an elderly or disabled person in addition to abandoning a child. Importantly, this applies only to an offense that's committed on or after the effective date of the act. If the offense is considered committed before the effective date, if any element of the offense was committed before the effective date of that act. Moving on to House Bill 2658 by Representative Leach. This adds a new termination ground, so a new letter to the alphabet under 161.001, and it adds termination ground V that allows for termination if a parent has been convicted of criminal solicitation of a minor, either online or in person, and it applies to suits affecting the parent-child relationship that are filed on or after the effective date. Moving on to House Bill 2660 by Representative Alverson. This is a bill regarding law enforcement investigations of certain missing children. So it amends the Code of Criminal Procedure, Article 63, so that regardless of when a child went missing, the law enforcement agency that receives the report of the missing child has to immediately investigate and within no later than 2 hours, enter the name of the child into the Clearinghouse and National Crime Information Missing Persons file, as well as entering it into the Texas Law Enforcement Telecommunication System or a successor system. Not later than 48 hours after receiving the report, the agency must electronically submit to each municipal or county law enforcement agency within 200 miles of the report any information that may help determine the present location of the child. It also requires that not later than 30 days after the report is received, the law enforcement agency must enter the name of the child into the National Missing and Unidentified Persons System, including all available identifying features, and also inform the person who made the report about the actions that have been taken by law enforcement thus far. If the agency determines the location of the child, the law enforcement agency, and they have reason to believe that the child is a victim of abuse and neglect, the agency has to notify DFPS, and the agency may take possession of the child under Family Code Chapter 262. DFPS may then initiate an investigation into the allegations of abuse and neglect and may take possession of the child as authorized under 262. Moving on to House Bill 2671 by Representative Cook. This is also effective September 1st, and it relates to the timing of a temporary orders hearing when a court orders a case to mediation. So this applies both to divorce actions under Family Code 6.502 and also suits affecting a parent-child relationship under 105.001. So if a court on its own motion refers a suit to mediation, and where there's already initial temporary orders hearing has not yet occurred, the court can't postpone that hearing for more than 30 days. So this is likely to apply mostly to family law cases, as not too many mediations and CPS cases occur prior to a temporary orders hearing, but there are some jurisdictions who practice pre-adversary hearing mediation, and those jurisdictions may want to be aware of this particular provision. Importantly, it applies to a suit that is pending in a trial court on the effective date of the act or that is filed on or after that effective date. Moving on to House Bill 2850 by Representative Smith. This is a very large bill that I won't be able to cover all of because it creates a new title under the Family Code entitled Civil Procedure and adds Chapter 301 under that code for discovery procedures for civil actions. And the first thing that new chapter does is clarify that this Chapter 301 applies only to civil actions brought under the Family Code. So it doesn't apply to civil actions outside the Family Code. It also states that notwithstanding Government Code 22004, this chapter may not be modified or repealed by a rule adopted by the Supreme Court of Texas. So it's really taking a lot of effort to codify these provisions. And what it does is it requires a party seeking disclosures to serve the other party not later than the 30th day before the last day of any applicable discovery period with a request for disclosure. It also establishes some required language for making disclosure requests. It codifies provisions of the Texas Rules of Procedure 194 and 195 regarding the content of those disclosures, and also requires a party to respond to a discovery request by the 30th day after being served with the request. However, if that request is served before the defendant's answer is due, the response is not due until the 50th day after the request. Responses regarding expert witnesses are governed by Family Code Chapter 301, Subchapter C, which is also a new provision created by this bill. It also deals with voluminous discovery. So a party who is responding to a disclosure request has to provide copies of documents or other tangible items unless 4 things apply. The documents are voluminous, the responding party states a reasonable time and place for the production of the documents, the responding party produces those documents at the time and place unless otherwise agreed or ordered by the court, and the responding party provides the requesting party with a reasonable opportunity to inspect those documents. The bill also codifies provisions of Rules of Civil Procedure 195 regarding expert witnesses. This is, again, it's a fairly big bill. I don't have time to cover all of it here, so I highly encourage everyone to kind of review and be familiar with the provisions of this act. It applies to actions that are filed on or after the effective date of September 1st. Moving on to House Bill 2969 by Representative Cook. This bill relates to whether or not someone is too old to be an adoptive parent. So it actually adds a new provision under Family Code 162 that restricts DFPS or an SSCC for jurisdictions who are under community-based care from setting a maximum age or a maximum age differential for an adoptive parent. So that you can't have an arbitrary sort of bright line rule, but it does allow them to consider the health and expected lifespan of each prospective adoptive parent when determining the child's best interest. Moving on to House Bill 3186 by Representative Leach. This bill relates to diverting youth from the criminal and juvenile justice system. So it requires a child who is alleged to engage in conduct that constitutes a misdemeanor punishable by fine only, other than a traffic offense, to be diverted from formal criminal prosecution. It's a very big bill. It contains a lot of citations that are specific to the juvenile justice system, but I did want people to know that it does amend Family Code 264-302 to require DFPS to provide services to a child and their family if the services are available in the county and the child is determined to be at risk by a justice or municipal court under Code of Criminal Procedure Articles 45-309 and 45-310. Moving on to House Bill 3462 by Representative Noble, also effective September 1st. This is a bill that simply consolidates all of the DFPS ombudsman programs under HHSC. So all of the DFPS ombudsman programs remain, they're just housed under a different agency than they previously were. Moving on to House Bill 3474 by Representative Leach. This is, again, a very big bill that I won't get into all of because it amends various chapters of the government code as it relates to the organization of certain districts, statutory county courts, multi-county courts, justice courts, and criminal magistrates. So there's a lot of detail that I just won't get into, but there were a couple of revisions that I thought people should be aware of. One is that it raises the jury compensation from $6 on the first day to $20 on the first day, and from $40 on the subsequent day to $50 for each additional day. So that's what has to be paid by the county. It also raises the state reimbursement to those counties for jury compensation from $0 on the first day to $14, and then from $30 to $52 for each additional day. Moving on to House Bill 3554 by Representative Thierry. This bill relates to human trafficking, and it includes enhanced penalties and raises it to a first-degree felony if those violations occur within 1,000 feet of a juvenile detention facility, a children's shelter, or an RTC. Again, this applies to an offense committed on or after the effective date, and the offense was deemed committed if any element of the offense occurred before the effective date. Moving on to House Bill 3765 by Representative Busey. This is a bill designed to prevent children in foster care from having to transport their belongings in a disposable trash bag. So it amends Family Code 263008 to add having luggage available to transport the child's belongings to the Foster Children's Bill of Rights. It also amends Family Code 2641078, establishes new language that requires DFPS to establish a luggage program for children who are being removed or who are changing placements. That luggage belongs to the child and does not belong to the placement or to DFPS. DFPS will have to document and report the inventory of this luggage program and the number of times a child is forced to use a trash bag to transport their belongings. DFPS may solicit and accept gifts, grants, and donations to the program. I think we're now going to move on to House Bill 4233 by Representative Zwiener. This relates to runaway prevention. In order to try to ensure placements are prepared for doing what they can to prevent a child from running away, it amends Family Code Section 264 so that each foster parent, prospective adoptive parent, relative, or other designated caregiver for a child older than 10 has to complete a training program developed by DFPS on runaway prevention measures and proper procedures to support children and youth who may be at high risk of running away. Moving on to House Bill 4696 by Representative Noble. This bill transfers certain functions from DFPS to HHSC, specifically regarding children in state-supported living centers. So it requires DFPS to immediately notify HHSC of reports of abuse, neglect, or exploitation that are related to a child with an intellectual disability that is receiving services in a state-supported living center. It also requires HHSC, rather than DFPS, to investigate reports of abuse, neglect, or exploitation of a child receiving services from a provider as defined by Human Resources Code 48251. It also requires home and community support services agencies to report abuse, neglect, and exploitation to HHC directly rather than to DFPS. And this is our final House bill. This is House Bill 5010 by Representative Schofield. And this is not related specifically to child welfare, but it is related to attorneys because it affects grievances that are filed against attorneys. And essentially it makes two categories of grievances depending on who is making it. So the first requires grievances against an attorney to be classified as a complaint if they are submitted by the following persons in the proceeding that is the subject of the grievance. So if it's a family member in a ward in a guardianship proceeding, if it's a family member of a decedent in a probate matter, if it's the trustee of a trust or an executor of an estate, if it's a judge, prosecuting attorney, defense attorney, court staff member, juror in a legal matter, trustee in bankruptcy, or really any other person who has a cognizable individual interest or connection to the matter or the facts alleged in the grievance. So basically anyone connected to the matter is filed as a complaint. However, if it's someone who is not under that provision and has no connection to the matter at hand, then that grievance is classified as an inquiry and will be handled with those inquiry disposition procedures. So this applies only to grievances that are filed on or after the effective date of the act. And it's important to note that the attorney or the complainant can both appeal the designation if they don't feel like the designation was appropriate. And so now we are going to transition to our Senate bills, and I'm going to turn it over to our staff attorney, Amy Corbin, to talk about Senate Bill 24 by Senator Korkhorst, because Amy is our resident expert on prevention and early intervention services, and that's what this bill has to do with.
Thanks, Dylan. I'll give you a hot second to take some water. You've been doing a great job. So I'm going to talk to you about Senate Bill 24, which, as Dylan said, this impacts the prevention-related services. As most of you know, DFPS has a whole division focused on prevention of child abuse and neglect, and it's called Prevention and Early Intervention Services, or PEI. And so Senate Bill 24 moves the entire division from under DFPS, and it's going to be housed under a different state agency, the Health and Human Services Commission, HHSC. Along with that move is going to be a code move. So Senate Bill 24 deletes Chapter 265 of the Family Code, this oversaw PEI, and it shifts and creates a new chapter under the Human Resource Code, and that's 137. During this shift, PEI is going to receive a new name. So you're going to start hearing about Family Support Services instead of Prevention and Early Intervention. There's going to be a new definition of at-risk family and a few other differences between PEI and the newly named Family Support Services is that Family Support Services is going to primarily only administer contracts. There's no longer an evaluation component for those services, and there's no longer a requirement that those programs be evidence-based. Next slide. You will also start to hear a little less of the term primary prevention. So under Family Support Services, you're going to hear child abuse and neglect prevention terminology start to come forward. Some of the great PEI programs are specifically being transferred over, such as the Nurse Family Partnership, the Texas Home Visiting Program. And lastly, there's a new program being created called Thriving Texas Family, and this provides community outreach and support for women who have unexpected pregnancies. As you can see, there is a note, see bill for citation. It's a pretty hefty bill, but this is kind of the primary focus on our child welfare. So I'm going to pass it back to you, Dylan.
Thank you, Amy. So I'm going to move on to Senate Bill 26, also by Senator Kolkhorst, whose effective date is also September 1st. And this bill relates to preventing mental health crises for youth and hopefully sort of preventing some of the circumstances that lead to children entering CWOP or other high-risk situations. So what it does is it creates new language for Government Code 531, and it requires HHSC to establish a matching grant program for eligible community-based initiatives that promote the identification of mental health issues and improve access to early intervention and treatment for children and families. HHSC has to prioritize grants for entities that work with children and family members of children who are at high risk of experiencing a crisis or developing a mental health condition, and those grants have to be focused on reducing the need for future intensive mental health services, for reducing the number of children who are at risk of placement in foster care or the juvenile justice system, and reducing the demand for placement in state hospitals, inpatient mental health facilities, and residential behavioral health facilities. Moving on to Senate Bill 48 by Senator Zaffirini. This is a bill designed to help standardize forms regarding protective orders. So it requires OCA to develop and make available on its website standardized forms and other materials that are necessary to apply for, issue, deny, revise, rescind, serve, and enforce protective orders. OCA then must include a procedure to ensure that a copy of that order is transmitted to all the required parties and that all relevant information is entered into the statewide law enforcement information system regarding protective orders, as well as any other applicable databases. So it's really trying to make sure that that information is entered and standardized and gets timely in the databases that it needs to be in. Moving on to Senate Bill 135 by Senator West. This is a very simple bill that simply requires DFPS to record the results of home studies of relatives or other designated caregivers in impact so that they are in the data system that is specific to that case. It applies only to home studies that are performed on or after the effective date of the act. Moving on to Senate Bill 182 by Senator Miles. This bill is designed to prevent the circumstances that happened at the refuge in Bastrop. And it does that by amending Human Resources Code Chapter 40 so that DFPS employers or contractors who become aware of conduct engaged by another employer or contractor that constitutes a criminal offense against a person receiving services has to report that conduct to local law enforcement agencies not later than the 48th hour after the employee becomes aware of that conduct. The person will commit a criminal offense if they're required to make that report and they knowingly fail to make the report. There are some other provisions in this bill that I don't have time to get into here. So if you're interested in the subject, please see the bill for additional citations. Moving on to Senate Bill 578 by Senator Zaffirini. This relates to information that may be protected in a protective order. So it amends Family Code 182 to add the county of residence to the information that a court may protect as confidential in a protective order. That provision applies only to an application for a protective order that is filed on or after the effective date. It also amends Family Code Chapter 85 to add county of residence to the information that may be excluded from a protective order, as well as the address and phone number of the protected person's place of work. That provision applies to protective order regardless of when the protective order was rendered, on, for, or after the effective date of the act. Moving on to Senate Bill 593 by Senator Sparks. This is another bill that's already effective because its effective date was May 19th. And this relates to efficiency in licensing procedures for placements for children in conservatorship. So it requires HHSC to engage a third party to conduct an audit of rules, minimum standards, and contract requirements that apply to child placing agencies, to RTCs, foster homes, kinship homes, and adoptive homes. That audit also has to review the standards or oversight requirements to determine whether or not those standards or oversight requirements comply with federal laws, with rules, guidelines, and whether or not that standard or oversight is a best practice. It's a big bill that includes some other citations as well, but the effect is to try to streamline standards and make it as efficient as possible for people to get these licenses. Also important to note that it expires September 1st of 2025. Moving on to Senate Bill 614 by Senator Perry. This bill duplicates several of the provisions that we talked about earlier in House Bill 730 regarding PCSPs, but it does create an additional provision that is not included in 730. It has new language in Chapter 264 to require DFPS to publish a monthly report on PCSPs that includes the number of children placed under a PCSP, the average duration of a placement, the average duration of a placement during an investigation, and the percentage of children removed and placed in the managing conservatorship of DFPS. Importantly, it applies only to PCSPs that are executed on or after the effective date of the Act. Moving on to Senate Bill 718 by Senator Paxton. This relates to custody matters after a DFPS investigation, and it amends Family Code Chapter 157 to require a court to order additional periods of possession and access when court-ordered access was denied due to a DFPS investigation that did not result in a finding of reason to believe, unless the party that is denying access shows good cause as to why more access should not be granted. Now, importantly, this does not create a cause of action against DFPS or waive sovereign immunity. I think this is something probably more applicable to family law matters because of the reason that it only applies if an RTB is not found, but it's also something I think is important for practitioners to be aware of, and it specifically applies to suits affecting the parent-child relationship that are pending before a trial court on or after the effective date of the Act. Moving on to Senate Bill 855 by Senator Alvarado, effective September 1st of this year. This bill relates to judicial training on family violence and requires judicial training on family violence to include, all judicial training to include 1 hour on the dynamics of family violence per term in office or every 4 years. Judges responsible for family law or family violence matters must complete an additional hour of family violence dynamics training every 2 years. A judge, master, referee, or magistrate who is in office on the effective date of the Act must complete the required training not later than December 1st of 2025. Moving on to Senate Bill 870 by Senator West. This relates to child support enforcement and modification, and it does several things that are, again, not directly related to child welfare, but I think are relevant and of interest to child welfare practitioners, because one thing it does is it allows a court or Title 4D agency to require an unemployed or underemployed person to participate in a program that provides employment assistance, skills training, and job placement services. So that's new because it has an option other than direct employment to comply with child support obligations. It also amends Family Code Chapter 231 to allow the Office of the Attorney General to administratively adjust the obligations of an incarcerated obligor. And so that's important to know. It also requires the OAG to distribute child support payments received on behalf of a child that is placed in substitute care by DFPS to the appropriate state agency in accordance with federal laws or regulations. These apply to child support payments that are received by the Office of the Attorney General on or after the effective date of the Act. Moving on to Senate Bill 1379 by Senator Parker. This bill relates to financial security for foster youth. It is effective September 1st of this year, and it adds new language to Chapter 264 to require DFPS to establish a pilot program to assist foster youth in achieving financial security and independence. This program has to include an agreement with financial institutions to establish saving and checking accounts for foster youth between the ages of 14 and 21. The foster youth are to be the solo owners of the accounts and not have to have a co-signer. The financial institutions may not require maintenance, overdraft, insufficient funds, inactivity, or other penalty fees on these accounts. DFPS can partner with nonprofits and other foundations to provide matching funds for these deposits, and DFPS has to survey youth about the program and complete an evaluation of the program by December 31st of 2027. If DFPS is unable to enter into an agreement with any financial institutions, they have to report the barriers to be addressed. Also important to note that this does have an expiration date on it, so this legislation does expire January 1st of 2028. Moving on to Senate Bill 1401 by Senator Zaffarini, effective September 1st of this year. This relates to medical exams for a minor victim of sexual assault. So it amends the Code of Criminal Procedure, Article 56A, to require a healthcare provider to conduct a forensic medical examination of a victim of sexual assault who is a minor, regardless of when the victim arrives at the provider, if the victim, the person authorized to act on behalf of the victim, or an employee of DFPS consents to the examination, or if consent is provided as described by Family Code sections 32003 and 32005. A law enforcement agency has to refer a minor victim of sexual assault for a forensic exam, regardless of when the sexual assault occurred. Also important to note, this applies only to a sexual assault or other sexual offense that is first reported or for which medical care is first sought on or after the effective date of the act. Moving on to Senate Bill 1447, this relates to DFPS investigation training. So it adds new language to Family Code Chapter 261 to require DFPS to develop a robust training programs for persons investigating suspected child abuse and neglect. An investigator or an investigative supervisor may not be assigned to investigate or supervise the investigation of any case until the investigator or supervisor successfully completes the training program and passes the examination. Importantly, there is a delay on sort of the effective date of this act because it only applies to investigations of cases assigned to an investigator or supervisor after January 1st of 2025. And you can understand that delay because that gives them time to set up the program and design the exam and have people do the training and take the exam. Moving on to Senate Bill 1727 by Senator Schwartner. This bill relates to child welfare data sharing. So it amends Human Resources Code Chapter 203 to add the Commissioner of DFPS to TJJD's Advisory Council on Juvenile Services, and it requires that council to develop some recommendations for information sharing between agencies that serve children, including juvenile justice and child welfare. Moving on to Senate Bill 1841 by Senator Hinojosa. This bill relates to family violence shelters and contracts with family violence shelters, and it amends Human Resources Code Chapter 51 to define dating relationship and dating violence. And in regard to a service or a service model, it defines trauma-informed to mean that the service or the service model is provided in a manner that recognizes and responds to the signs and symptoms of trauma in and the risk of trauma to a victim of family violence to better support the victim and promote the victim's choice, trust, dignity, connection, and healing. Human Resources Code 131 is also amended to require family violence shelters to use a trauma-informed service model. It also makes further amendments to add services that can be provided by a family violence shelter to include advocacy for economic and housing stability, for physical, behavioral, and mental health needs, and for the needs of children who are the victims of family violence themselves, as well as the children of victims. Other services that can be provided include safety planning, community education, counseling, and peer support. And contracts with these organizations must specify that participation in these services is voluntary, and centers cannot require victims of family violence to participate in other services. Also, the effectiveness applies to contracts that are entered to or amended on or after the effective date of the act. Moving on to Senate Bill 1849 by Senator Kolkhorst, effective September 1st. This amends various chapters. Let me pause there. It amends Health and Safety Code Chapter 810 by establishing an interagency child protection database and search engine to compile and aggregate reportable conduct information that is maintained by DFPS, HHSC, the Texas Education Association, and TJJD. So again, similar to the bill we saw before, in an interest in making sure that agencies that touch on child welfare are sharing data regarding child welfare and child protection. Moving on to Senate Bill 930 by Senator Kolkhorst, the effective date of September 1st. This is, again, a fairly big bill, and it contains the legal recommendations from the Senate Bill 1575 work group that was created by the 87th legislature regarding procedures for placing children in a RTC or a Qualified Residential Treatment Center, or QRTP. Now, Senate Bill 1575 in the last legislative session codified into state law in relation to provisions related to QRTPs that were required by the Federal Family Violence Prevention Services Act, sometimes referred to as FFPSA. Now, what Senate Bill 1930 does is fill in some of the gaps that are related to integrating court reviews of QRTPs and RTC placements. And they do that by integrating those findings throughout the court process and creating a parallel structure for courts to conduct an initial and an ongoing review of RTC placements for children and youth in care. And one of the first things the bill does is it amends the duties of a guardian ad litem under 107.002. and it requires the guardian ad litem to seek the child's opinions and concerns regarding their current or proposed placement. Now, notably, this duty is broader than just an RTC or a QRT placement, as it applies to any current or proposed placement. And it's designed to encourage discussion prior to placement when feasible, because we know that youth engagement is critical for any placement decision, not just those affecting QRTPs or RTCs. It also amends Family Code 107002 to require that if a child is placed or may be placed in an RTC, the guardian ad litem has to review any information regarding whether the placement is appropriate to meet the child's specific needs. They have to meet in person with the child and provide to the court a recommendation regarding placement and whether or not that is in the child's best interest. The guardian ad litem may request a placement conference and may participate in any placement conference regarding an RTC, QRTP, or similar placement that is conducted by DFPS unless good cause is shown for excluding the guardian ad litem. The bill also makes changes to the duties of the attorney ad litem under Family Code 107004. So if the child, again, is considered for placement in an RTC or a QRTP or similar setting, the attorney ad litem must review any available information regarding the child's needs, including the CANS assessment, psychological evaluations, discharge notes, incident reports, counseling notes, to determine if the placement is in fact appropriate to meet the child's needs. The attorney ad litem also has to meet with the child to elicit the child's opinion regarding the child's current or proposed placement. The attorney ad litem has to advise the child regarding DFPS's request for placement, and they have to advise them regarding the likelihood of that request being granted by the court. The attorney ad litem also has to advocate to the court for the child's specific desires regarding the requested placement, and the attorney ad litem may request a placement conference themselves and participate in any placement conference that's conducted by DFPS regarding an RTC, QRTP, or similar placement. And unlike a guardian ad litem, they may not be excluded from that placement conference. It also amends Family Code 10700131. This also allows a parent's attorney to participate in case staffings that are related to placement of their child in an RTC or a QRTP. It also defines an RTC per Human Resources Code, Chapter 42. And the purpose of that is so that everybody is speaking the same language when they refer to an RTC, so that they know exactly what kind of facility they're referring to. The bill also makes changes to Family Code 263002, and these relate to the initial placement decision. Some later sections of the bill address the provisions regarding ongoing court review. And so for placement reviews under Chapter 263, if a child is placed or is waiting for placement in an RTC, the court has to determine whether the child's needs can be met through placement in a family-like setting and whether the RTC can provide the most effective and appropriate level of care for the child. They also have to determine if the RTC is the least restrictive setting, consistent with the child's best interest and individual needs, and whether or not the RTC is consistent with the short-term and long-term goals for the child as specified in their permanency plan. Now, to make this determination, the court may consider any medical, psychological, or psychiatric assessments. They can consider the child's current treatment plan and the progress being made. They can consider any significant medical, legal, or behavioral incidents involving the child. They can consider the reasons for the child's discharge from their current placement or their former placement, as well as consider the programs available at the RTC and the RTC's discharge plan. They can also consider whether there are other programs that more effectively meet the needs of the child and any other relevant information. Now, these language is very similar to that required for findings for QRTP placements, that requirement by, again, the Federal Family First Prevention Services Act and Family Code 2630021 that is specific to QRTP. So it's meant to sort of model and parallel that language. It's also important to note that in order to make those findings, the court will have to rely on information that's provided by attorneys in the case. It's equally important that attorneys know and have access to all of this information. And that sort of list of enumerated sources is there to help encourage the use of existing documents and assessments to help inform the court's decision so that new assessments and new documents don't have to be made. Moving on to changes to Family Code 263202, these are changes to the status hearing findings, and the court is required to find at a status hearing whether or not continued placement in an RTC or a QRTP is appropriate according to Family Code 263002 and 26300201, respectively. Now, through previous legislation last session, ongoing court review of QRTPs and status hearings and permanency hearings was established. And what SB 1930 does is it adds review of RTC placements to those same provisions so that ongoing court review of RTC and QRT placements is the same, and it's now cross-referenced throughout all of those hearing statutes. So the same provision has been added to the status hearing. Again, the similar provision has been added to permanency hearings prior to a final order, and it has also been added to permanency hearings after a final order. So the same language has been applied in all of those hearing statutes. The bill also makes changes to Family Code 264018 regarding whether or not placement of a child in an RTC qualifies as a significant event. So it adds placement of a child in an RTC or a placement conference to determine the appropriateness of an RTC to the definition of a significant event requiring notice to the parent, the attorney ad litem, and guardian. And what that does is it triggers those individuals to be notified within a 10-day time frame so they can prepare for that event. Moving on to Senate Bill 2120 by Senator Zaffirini, that's effective September 1st. This is, again, a very substantial bill that grants the Texas Indigent Defense Commission the same authority over court-appointed representation of parents and children that they have long had over court-appointed representation of indigent criminal defendants. Unfortunately, this authority did not come with money, but they will now have the authority to ask for money next session to do some of the work that they've been authorized to do. And one of the things it does is it amends Government Code 79 to add serving as an attorney ad litem to the definition of assigned counsel programs and defines an attorney ad litem to mean a court-appointed attorney for a child or an indigent parent in a suit filed by DFPS. It defines a contractor defender program to include representation of indigent parents and children in a suit filed by DFPS, and defines family protection legal services as services provided by an attorney ad litem, an investigator, a social worker, a forensic expert, a mental health expert, or other similar expert to indigent parents and children in suits filed by DFPS, and importantly, also investigations conducted by DFPS. So that means that these services could apply even prior to DFPS filing suit. Offices of parent and child representation will have the meaning that is assigned to them under Family Code Chapter 107. And it also grants TIDC the authority to develop policies and standards for providing this family protection services representation to indigent parents and children. That may include performance standards, it may include qualification standards, it may include successful completion of CLE, as well as testing and certification requirements. TIDC can set standards for caseloads, they can set standards for compensation, for determining indigency, as well as policies and standards for assigned counsel programs, for offices of parent and child representation, for contract offender programs, and managed assigned counsel programs. So this is some fairly substantial authority that's being granted to the Texas Indigent Defense Commission. It also requires TIDC develop a plan that establishes statewide requirements for counties to report family protection services information. It uses that information reported by the counties to monitor the effectiveness of the county's family protection services, legal services, policies, standards, and procedures to ensure that they are in compliance with the requirements of state law regarding family protection legal services. TIDC can also revise the plan as necessary to improve the monitoring of family protection services. And TIDC has to report annually on the data collected and the quality of legal representation that is provided to parents and children as compared to state and national standards, and has to report its efforts and its recommendations to improve the quality of representation that's being provided. It also requires each county to biannually report a copy of all of its formal and informal rules governing the procedures the county uses to provide indigent parents and children with counsel, as well as any fee schedule used by the court and information on the court's compliance with Government Code Chapter 37, including the list of attorneys and the rotation system that is required under that chapter. Counties also have to annually report information on the number of appointments made to each attorney and information provided to the county by those attorneys under new Family Code Chapter 1070042, which we'll get to in a little bit, because that's something that will apply, I think, to most people on this doing this webinar. Moving on to Government Code 79, TIDC must also provide technical assistance to counties to improve their systems in providing these family protection legal services, to promote compliance with state law, to assist counties in providing or improving their family protection family protection legal services, and they can do that by distributing grants of any funds appropriated, and they can monitor each entity that receives that grant and enforce compliance with the conditions of the grant. So those funds will then be made available based on compliance with standards and state law. And importantly, the county cannot reduce the amount of funds provided for family protection services because of the funds provided by the grant. So in other words, if TIDC provides funding to a county to increase the quality of representation, the county simply can't use that funds to decrease the amount of money that it's currently spending. It has to be in addition to, not a substitute of. Also important to note that TIDC may participate and assist counties in the creation, implementation, and operation of computerized systems to assist in the provision of these family protection legal services. And that system can be used to collect data from those counties regarding representation of indigent individuals. And TIDC can use some appropriated funds to help pay for the cost of that technical training and provide that technical training to counties. Now moving on to Chapter 107, this is the provision I mentioned earlier. So each year, and on a form prescribed by TIDC, attorneys who are appointed as an attorney ad litem in a proceeding filed by DFPS have to submit to the county or TIDC a report for the preceding fiscal year that describes the percentage of the attorney's professional practice time that was dedicated to the attorney's appointment as an attorney ad litem in that county. Now, this is something that's long been required of criminal court-appointed defense attorneys, and now that same reporting of practice time will be required of attorneys representing parents and children in DFPS cases. And finally, the bill requires that a chief counsel for an office of child representation has to practice law for 5 years instead of 3. So it heightens the requirements for those people to serve as chief counsel for offices of child representation. And I believe we are now at our last bill of the presentation. This is Senate Bill 2261 by Senator Blanco. Its effective date is September 1st. And it amends Human Resources Code Chapter 40 to require that DFE employees have to successfully complete their training program. So we saw some training programs established earlier, and this requires them to be successfully completed. So I believe that is all the bills that we have. And Amy, I think we have time for some questions, but before we get to questions, as promised, I want to make sure that the MCLE information is provided to everyone. So I'm going to put this as our slide while we go through any questions that came in.
Thanks, Dylan. Yeah, we actually have quite a few questions. So there's 2 that are related to PCSP, so I'll start there. One question is, how might the new provision apply when a temporary placement is with another parent who is not being investigated?
That's an excellent question, and it's so good I don't have an answer to it because it's a little bit tricky in terms of whether or not that is a placement outside the home. I think particularly if you take some of the changes that were made in the prior legislative session, in the 87th, there was certainly a very strong emphasis on the legislature for sort of considering equally a sort of custodial parent and a non-custodial parent. So it's tough to say how that would apply to this PCSP situation. I'm not sure. So that's the best answer I can give you, honestly.
Thanks, Dylan. The next PCSP question is, PCSP generally is a way to avoid removal. Prior to removal, the parent is entitled to counsel. How would you reconcile that with these changes that were made?
So I think that's a really good question, and it's a tough question because what the bill has done is essentially really heightened a parent's awareness of their right to counsel. But that right to counsel does not apply at the investigative stage. It doesn't actually attach until you've sort of proceeded beyond the investigative stage. You've either proceeded to removal or to a court-ordered services case. So I think there's certainly a tension there where a parent is being informed of their rights, particularly of their right to counsel, but that right to counsel isn't going to attach unless circumstances sort of escalate to the point where the court is involved. So I think it is certainly a tricky situation to navigate. My hope is that the Texas Family Helpline gets a lot of calls because I think they're probably best situated to sort of fill that gap between when a parent under investigation is notified of those rights and when they actually have the right to counsel attached. I think they're really sort of the only organization I can think of that's designed and suited to sort of fill that gap.
Great, thank you. Our next 2 have a little bit to do with the ex parte hearing. So the first is, it says under code 261.303, which is the interference with investigation court order. It says, how can a court render a finding it has probable cause to believe that there is no time allowing for a hearing if you can't have a hearing? And if a court doesn't find it and you've had a hearing, and then have you violated the no ex parte provision? If this question makes sense to you.
It does, and unfortunately, it makes so much sense that I don't have a good answer for it, because I think it's a really excellent question. Because I think as the bill is written, as the questioner points out, it sort of contemplates an action taking place before the ex parte hearing happens, but there really isn't anything before the ex parte hearing happens. And particularly, there's not a function of an affidavit in a order of invade of an investigation. So I think that's a really excellent question. It's a tricky field. I don't have an answer. What I will say is at least on the old law, I think there was some ambiguity there as well about whether or not an ex parte hearing was required and when it was required. So I think this was an effort by the legislature to clarify that. So it allowed for an ex parte hearing to happen, but sort of define what circumstances allowed that. And there's certainly some hiccups that I think will take place in trying to for courts and attorneys to navigate those procedures. And I think you've identified one.
And along the same questioning as an ex parte, are ex parte hearings done by submission? Are they even allowed after September 1 of 2023?
You know, that's another question that we've had asked to us. I think that's something that we don't have a clear answer on right now. It's, if you look at the clear language of the statute, it requires a recording to be made, and that recording can either be audio or video or by authorized court reporter. So it clearly wants one of those three methods. So I don't think, for example, like an email receipt would qualify under that section. So for jurisdictions that do, practice hearings by submission, I think it is going to be a challenge as to how to have those hearings that have been established comply with the new procedures, because, like I said, the bill establishes three pretty clear options and doesn't have an exception to those three options.
Great, thank you. Our next question relates to House Bill 1087, which requires the emergency removal affidavit to describe with specificity in a separate section all the reasonable efforts made to prevent removal. And so the question is, do you anticipate that with this House bill will lead to DFPS taking PMC without termination due to the challenges related to finding clear and convincing evidence of reasonable efforts? And will termination be much more difficult to get now?
You know, it's a tough one because it clearly establishes a third prong. Right. So you used to have a two-prong test for termination. It was you had to have one of the statutory alphabet grounds of action done by the parent that justified termination. And then you had to have clear and convincing evidence of best interest. And now you have this third prong. And if you think of a three-prong test, the reason why you add a third prong is for cases where you would have the first two, but not the third, if that makes sense. And so if you think about cases where you would have a finding regarding termination ground and you would have a finding regarding best interest, but then not have the finding regarding clear and convincing evidence regarding reasonable efforts, what kind of case that would be, where you've got, clearly the termination is in the best interest, clearly the parent did something wrong, but also you don't have the reasonable efforts finding. That's going to be a very sort of tricky kind of case. So I think that is something to be mindful of sort of what the consequence would be if termination is not found on that ground, but when you have evidence to meet the other two. I think it's also important to note sort of the consequences of having the escape hatch of aggravated circumstances, because if a court finds aggravated circumstances, that alleviates the burden of having that reasonable efforts finding at termination. I'm not sure whether or not that's going to serve as an incentive to make aggravated circumstances finding. In my practice, I found that happen very, very rarely. It's possible we might see those findings increase because of the effect that it has on the termination proceeding.
And along those same lines, this person said that they kind of missed some of your reasonable efforts portion. So are you saying that if they have a placement, they can no longer remove as far as reasonable efforts. If there isn't a placement, then they can no longer do a removal?
No, I don't think that's the thrust of any of the reasonable efforts changes. It's not that if there's a placement, you cannot do a removal. I'm guessing they might be referring to House Bill 968 by Representative Gates. So that provision required, again, it required for removal, DFPS had to put in their affidavit why a kickout order would not be sufficient or why a PCSP would not be sufficient to prevent removal. So that's what 968 does. I don't think it necessarily says if you've got a placement, you cannot remove. I don't think it means if you do have a PCSP, then you cannot remove. I don't think that's the effect or the intent of that provision.
They go on to kind of add another provision that it's a little concerned that because PCSPs are voluntary, if the parent can kind of renege or change their mind and go and collect the child, have you lost that exigency? Is there any guidance for this voluntary, agreement that they then change their mind on for that?
So that's a good question, but I will say, of all the changes made to PCSPs were always supposed to be voluntary. So, they were never written binding legal agreements. They were always voluntary in nature. And really what the bills do isn't change that voluntary nature. What they do is change the requirement to let the parent have an informed understanding of that voluntary nature. I will certainly agree that it's a little bit challenging to explain, here's an agreement that you have, but nothing will happen if you don't follow the agreement. That's certainly, I think, a hard thing to try to explain. But the agreements were always voluntary, and PCSPs were never legally binding. So most of the changes don't really affect that. They simply affect how a parent is told or informed about the nature of the agreement.
Definitely lots of PCSP questions. And I don't know if you'll have the answer, but someone wanted to know if DFPS, the agency, is going to have any info or resources for these alternative caregivers who have PCSPs. So programs of churches, nonprofit agencies that can really assist and support these placements with the agreement of the children placing there. Do you know if there's any plans to create a resource list?
I don't. That's a good question. What I will say is, I think one of the issues that the PCSP legislation was designed to prevent is children lingering indefinitely in PCSPs. I think that's definitely clear from the legislation that is passed, is there were circumstances where sort of a child was in a PCSP and DFPS would simply sort of leave the situation as is, and the caregiver would be put in the situation where they didn't have legal authority over the child, they didn't have legal custody, but the child was in their care, and they had the sense that they couldn't do anything other than have the child in their care, or else DFPS may accelerate their involvement. So the legislation, by putting those time limits on PCSPs, I think the intent there is to prevent that circumstance where those placements are sort of lingering indefinitely and don't have access to services and don't have access to support while they're caring for children sort of year after year. But as far as providing that specific list of supports, I'm not aware of that. DFPS may be working on that, but I don't have any information about something specific in their efforts to do that.
Great, thanks, Dylan. We're going to switch a few gears. So one asks about 20.A.02, which is the trafficking provision. Do you know if that's going to apply to CWAP locations as well as the RTCs and detention centers?
That's a good question. I'll have to go back and double check the language. I would highly recommend looking at the specific language of the bill. I do not believe it does. In other words, I believe the language is specific to RTCs, children's shelters, and juvenile facilities. So I think the locations are specific. I don't think that CWAP locations are included. Partially, I think because CWAP locations are sort of hard to define. I'm not sure they have a definition sort of under the family code of how you define a CWAP placement. I can certainly see why there would be an interest in doing that, because children are certainly highly vulnerable in that circumstance. They're probably more vulnerable there than they are at any of those other facilities to being enveloped into human trafficking. But unfortunately, I don't think that was included in the bill, but I would highly recommend looking at it and see if there's any flexibility in that language.
Great, thank you. Our next question is about, are funds being made available for the added requirements for the guardian and attorney ad litem to meet with the children in person, and for the annual reports of percentages that the county needs to be worked in? Do you know if there's any additional funds that are going to be made available?
There's no additional funds available. What I will say is that the authority granted to TIDC does mean, and this is what I probably didn't highlight this enough, this didn't happen in this section, but now in the next session, TIDC can ask for and receive state appropriations for funding for court-appointed representation of parents and children. And that would be a first. We have never had state funding for court-appointed representation of parents and children. Now, how it works in the criminal defense system is that TIDC uses those grants to what they call formula grants and improvement grants. So they use a certain level sort of base funding to supplement the county spending on representation. And then they also have grants communities can apply for specific projects that enhance representation. So what I understand in talking with the folks at TIDC is they're not, I think, bound completely to using that kind of formula to enhance parent and child representation, but the possibility of state funding to support parent and child representation is now real. And that's a significant change. We have not had that before. So is there any funding regarding those new specific duties? I'm afraid not. I'm afraid there's no new funding that is specific to those duties, but there may be funding coming soon in the next legislative session that could be more general funding or for specific projects within jurisdictions.
Great. Our next question asks if there were any changes to allow final or temp SAPSR orders to end a court-ordered services case. So can a COS case be filed as a SAPSR?
That's an interesting question, and I think there's been a lot of debate about that as to whether or not a court-ordered service cases either can or should be filed as a SAPSR. So that was definitely an open question, I think, after the reforms of the 87th legislative session. What I will say is there wasn't any legislation to specifically address that issue. The only legislation that was passed that specifically sort of clarified some of the legislation regarding court-ordered services was that provision in 730 that clarified that the court cannot order a child to be placed outside the home under a court-ordered services statute. So that was the only legislative amendment that was specific to 264-203. So, I mean, I guess the question is, you know, could a parent, by reaching an agreement in a SAPSR, sort of forestall or sort of close out their own court-ordered services case? There wasn't any legislation that addressed that. That's the best answer I can give you.
Okay, thanks. Our next question is, does a non-biological parent who lived in a home prior to the removal of the children have a right to supervise visits with that child? And then the note is only one of two children removed was his biological child. DFPS has refused to allow visits as they're not looking to reunify with this non-biological child and this parent.
Okay, I just want to make sure I understand it. So it's a parent who is the biological father of one of the children, but not the biological father of other children, and they are requesting visitation with all of the children in the case.
That is correct.
That's a tricky circumstance. I can tell you there certainly wasn't any legislation, you know, that affected that circumstance directly. You know, there's definitely been, like I said before, interest by the legislature in the rights of sort of non-custodial parents and making sure that they are treated equal in cases. As far as the rights of a non-biological parent, that's, again, no legislation I think is specific on that. So I think arguments regarding that kind of have to be made in terms of equity and relationship. What I will say is that a person can have an important relationship in the child's life, whether or not they are in fact the biological, you know, parent of the child. Like certain arguments can certainly be made for family connections, and we make those all the time in terms of other people that are related to the child that are not biologically related. They could be coaches, they could be teachers, they could be other people in that child's life. So I think simply because that person is not the biological father of the child certainly shouldn't necessarily exclude them from visitation, even though it may not entitle them to visitation.
Great. Well, I think we are just about out of time. And so we didn't get to all of the questions. There are some amazing ones, but please email us at thechildren@txcourts.gov, and we can answer any questions that might have kind of been unanswered. And I will let you close this out, Dylan.
Thank you, everyone. I just want to say, We really appreciate the engagement. Please make sure that you report your MCLE hours. The PowerPoint that was made part of this presentation will be available on the Children's Commission website, as well as our legislative update that will break all the bills down by their House bill and Senate bill, and as well as breaking them down by sections of the family code and other codes that were affected. And then it will provide more detail than I was able to get to in this presentation. So I think that will be a lot of value to people. So please utilize that resource as soon as it's available. And I will wish everyone a wonderful afternoon. Thank you for joining us.